Welcome once again to The Law Matters. Of course it does. Hi, I'm Debbie Moraes, your host and moderator. As we tell you, this program has been created to inform, help you, educate you with law matters because the law matters. Understand the law better and you're in a better position to decide how to protect yourself, your family, and your business. We continue to provide information and resources that'll help you decide whether you want to contact a lawyer. Perhaps will help you to determine that you can handle some issues yourself. If you do need additional professional counsel, they'll be better prepared, and as a result, hopefully you will achieve better results. That's our goal. Save time, save money, achieve the best possible results. The Bazar and Associates law firm in East Providence continues to donate their time and their expertise and offer their insights on the various topics that we tackle. So we want to, of course, welcome and thank once again Attorney David Bazar.
Thank you, Deb.
So today, we have talked about it before, today we're going to be handling jury trials. If you've never been asked or never served, today we're going to cover some of the questions that others pose, both before and after they've served. There's often an ongoing debate about the jury's objectivity and their fairness, and what about there being prejudice. So the news frequently displays, or for all of us to see, that it's the jury of your peers that's often fraught. And then, of course, who decides whether it's judge or jury? Who decides who the jury's going to be? By what criteria? And now, should we even consider getting rid of juries? Well, I think let's go back to where we first started, which is what is a jury trial versus a bench trial, and go through the process.
A bench trial is a trial with just the judge sits as both the person to decide the facts and the law on a case. A jury trial, obviously, is a trial with a jury where the jury decides the facts and the judge decides or instructs on the law. So there are certain cases that you are automatically entitled to a jury on. There are other cases where you have a right to a jury, but you have to request it. A criminal case with a felony, that type of thing, you have a right to a trial in the first instance with a jury. And that's in Rhode Island, a jury of 12 with 2 alternates usually. And a decision based on that trial by that jury is a unanimous decision of all 12. In a civil trial in Rhode Island, a jury is usually 6 with 2 alternates, and again, it's a unanimous verdict. The jury deliberates, and if they can't reach a decision, the judge will instruct until hopefully they can come to a conclusion.
Who actually gets to decide whether the case is going to, at times when you have an option, whether it's going to be jury or judge? Who gets to determine that?
In a criminal case, the defendant can waive his right to waive it. Most cases, misdemeanor, in the first instance heard in district court, you sign a form saying, do you want to have a trial in the district court? And if so, you waive your right to a jury in the first trial. The reason you can do that is because if you lose, you have an automatic right of appeal to the Superior Court, and then again have the right to a trial with the jury. If it's a felony, it's in the Superior Court in the first place, and again, as the defendant who is being charged, and it's your constitutional right to a trial by jury, you have the right to decide whether or not you want to waive that right. In a civil case, either the plaintiff or the defendant in a case that's filed in Superior Court has the right to ask for a jury.
If you are working with someone as their counselor, as their attorney, what factors do you consider when you're talking to your client about what he should do?
So if I have a civil case and we are going to file in Superior Court, I'm always going to request a jury trial. There are a number of options to get the case resolved prior to trial, but in the end, if I can't settle it either through mediation or arbitration or some other alternative dispute resolution method, I want to have my right to a trial in front of a jury.
Why?
Because the jury understands life every day. They understand what people are going through and what kind of suffering there is. And I believe that that is the best chance to get a fair resolution of what you're claiming to be, in most cases, your injury, and as a result of what was done to you. And I think it's a system that works, and it's worked for a long time, and I believe in that system.
What do you say to the fact that there are so many cries of prejudice, society's prejudice? They aren't fair. They have their dispositions. They've had their cultural boundedness. What do you say to that?
Well, I say this. When you're selecting a jury, there's a process called voir dire. And in that process, both sides get to question the jurors, and you have a right to challenge a juror for cause if there's a reason why they can't sit fairly and impartially on your jury. And you have a right to a preemptory challenge, which is, as long as it's not for some prejudicial or there are certain bases that you're not allowed to, but for the most part, if you just don't like how somebody feels, you can have them removed. There's only a certain number of those challenges that you get, but it's the process that we use to end up with the most fair and impartial jury that we can get for a trial.
So do you have, you mentioned the preemptory, do you have a limit to 3 that you can disqualify without comment or without apparent reason?
There is, without cause.
Without cause.
There is, so I do civil trials, and the last trial that I did, the judge liked, and I liked the process that the judge used, because usually you select 6 jurors in a civil case and then 2 alternates, but the alternates know they're the alternates. So are they paying as much attention? Do they know whether or not they're going to get to deliberate? Do they think, well, at the end of the day, all 6 are going to be here, so we're not? So what this judge did was he said, let's pick 8 jurors. At the end, the 2 attorneys get to decide whether to let all 8 deliberate, or if we're then going to go through and again draw and pick which 6 are going to deliberate. So all 8 get to be seated at once, and since that's the case, you get 2 challenges for every juror, so you get 4 challenges.
Got it. I understand.
Yeah, 1 challenge for every 2 jurors.
1 for every 2 jurors. I got it. So on one of our favorite television shows where they're talking about jury selection, apparently you see the attorney asking what seems to be very peculiar questions. True, not true, and do you do it?
Yes. And some of the questions I might ask might seem very peculiar, or imposing or diving too far into someone's privacy, and we explain that. So the last trial that I had, the judge did a lot of the voir dire, asking the questions.
Is that common?
It depends on the judge, and it's more and more common, and I think it actually is a good way to do it, because you still get to ask your questions.
Okay.
So in this particular case, the judge asked the standard questions that we would all want to know. Have you been on a jury before? What was the result of that case? Have you had a lawsuit before? What was the lawsuit about? What was the result of that case? Obviously, you're asking those questions to find out what experience the potential juror may have had with the legal system and jury trials, and what effect that experience might have on their ability to sit and listen to a case fairly and impartially. Then there are questions that you might ask that are more geared to your specific case. So if you had a case where you have a client who was not born in the United States, for example, and his or her testimony might be very relevant to the case, and they may or may not be able to testify in English because it's their second language, you might want to get some sense from the jury as to how they might feel about that person, or there might be some slant one way or another. So how are you going to get at some of that? So one of the things I've thought of doing and might consider doing or may have done is to find out where the jury gets their cable news from. So I'm not going to just dive right in and say, do you watch MSNBC, Fox, or CNN, or something like that? But I might ask, what do you like to watch on TV? And you get actually a lot of different answers that may have some subtle impact on how you might feel about that juror that might be on that jury. And so what do you watch on TV? You get a response. One time I got a response, I like to watch Law and Order, which I like to watch too.
Sure.
But I needed to remind the juror and the jury that that's TV and this is the real world. And those lawyers, you can't hold me up to the same standard as those lawyers on Law and Order because they have a script.
Yes.
And we don't. And it's a way to do two things. Number one, you want to connect to the jury, and you want them to see your case and you for what it is as real people in real life. And you also find out a little bit more about them. So this person has an interest in the legal system, they have an interest in justice perhaps. And so that's a little bit of, a feel for what that person is about and what they like and what they'll respond to. And of course, then you keep digging in. All right, so you watch this on TV. What else do you watch? And where do you get your news from? Some like to tell you they get their news from the local stations. Okay, which ones and why and who do you like? And just a conversation a little bit about that. You might find something else about them in going through that conversation. And then just drilling down a little bit. And at the beginning of that whole process, I'll tell them, as would any attorney and the judge, that we are not trying to pry into your private lives, but we want a fair and impartial jury, and we're just trying to learn a little bit about you so that we know who you are.
Do you want an educated juror?
Sure, but educated in what?
That's where I want to go with that. So if someone were to ask you that, how would you play that out a little bit? So I understand you want them to watch news, and maybe you care about them being up on current law a little bit because they saw what's in the news, they read what's in the news. Do you want them to have heard about the case? Maybe it hit the news. Would you care? Does that disqualify them? Where do you go with that?
Here's the thing. Again, remember the goal is a fair and impartial jury. You want them to perhaps have a predisposition to your side of the case, if that's at all possible, but the other side wants a predisposition to their side of the case.
Exactly.
So that's why with the same number of challenges and the same number of, the challenges for cause, you'll end up with a fair jury because I'm going to look for people that I like for my jury, and the other lawyer is going to look for people that he or she likes from their perspective. So when you say, do you want an educated juror? Well, yes, but educated in what? And again, what is your case about? And what do you want them to be inclined to know or do or like? So if you have a medical malpractice
That's where
case,
it's going to go next. Good.
you may not want a doctor on the panel for obvious reasons, and you may not want a nurse if for certain reasons, or you may because there may be some complicated medical issues that they might be able to understand and explain. So it's not a science. It is a science, really, but to me it's an art because I'm not trained in the science of picking a jury and all of that. I do it based on my gut feeling about a person and trying to connect to that person and how I think that they'll respond. And I know there are TV shows and movies where there is a science to it.
Yes.
So I do believe that there is a social science that people can go and study and say, for your jury, you want this, 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 and this. I've never had the resources or case where we would spend the kind of money to hire somebody to find out what that jury consultant can deliver. I've always tried to do it based on my gut feeling as to how in interacting with the potential juror and how I think that they would then interact with the evidence that's presented to them.
And let's just carry that a little bit farther in one regard. So if you are to defend someone, your case, if you have a very solid case of evidence, a body of work that's going to clearly defend your client, then I'm thinking that perhaps having an educated nurse, doctor, whatever we're in that case, that would be a good thing for you. if you didn't have every T crossed and every I dotted in terms of the delivered goods, the evidence, how does that impact on you and your selection?
So am I defending a medical professional
Let's
in
go
a
with
malpractice
that. Let's go
case?
with that because you started with that, David.
Well, if I was defending a doctor and I thought I had a really good case, there's no way the other side is going to allow me to keep as many doctors or nurses on that jury as I would like. I wouldn't think. But I would look for people who can understand a complicated issue if it is complicated. But what we try to do is simplify it so that this is what the doctor did or the medical professional did. This is the standard of care. And you want them to be able to understand that they followed the rules and didn't deviate from the standard of care. And even if there's a bad result, sometimes bad things happen, but it's not as a result of negligence because it's not as a result of something that the medical professional did that any other medical professional would have done differently or that they deviated from the standard of care, as we call it. On the other side of the story, if I'm representing the plaintiff who had a bad result in a case where we can show, and we believe we can show, that there was a deviation from the standard of care, I'm not 100% sure all the time. I'm looking for exactly the opposite type of juror, because I might want someone who can understand that they didn't do what they were supposed to do. But I do want to find someone who's going to have that compassion and feelings for, wait, there was a wrong done here, and I want to correct that wrong.
So how do you get at, if you will, whether or not potential juror has the degree of empathy or some level of empathy or the ability to be other than just it's all black and white?
I think it's part of a conversation with the juror and listening to the juror as they answer questions about themselves, what they think about different aspects of life and work and all of those types of things. So that's the art of it to me as opposed to the science. And so since I've never done it from the scientific side, all I can tell you is that I like to really listen to what the juror is saying, just like I would like to listen to what anybody is saying, understand what they're saying maybe and what they're not saying sometimes. And sometimes just dig in a little bit more on that so you can really get a sense of who they are and where they're from. In a jury trial that I did, there was a fellow who didn't really say anything that would have been like, wow, I can tell from what he's saying, there's no way he's going to ever have empathy for my client, feel for my client, understand my client, understand the case that I'm presenting. Nothing he said gave me that sense, but I just had a feel about him, because it was a guy, that I like a sense that he didn't like me, he didn't like my case, he didn't like my client. So that was one of the challenges I would have used for no cost, the preemptory challenge.
Does a juror who's being questioned by you and then the other side, whatever the other side is, suppose they just have bad feelings about the case, they really don't want to do it, do they have the right to say, you know, I just don't like, I don't know, a case about drug possession or whatever it is? Do they have a right to do that so that they can be excused, or do they just plain give you an answer that they think you will find objectionable and then you'll dismiss them? How does that work?
So if there's something that comes up that may have a juror excused for cause, most judges will then take them to what we call the sidebar, away from the rest of the jury with the stenographer, and ask questions. And there'll be some in-depth questions to find out, is this juror just trying to get dismissed from the jury, or is there really some deeply held bias that really would interfere with their ability to sit as a fair and impartial juror? And judges have done this a lot, lawyers who have done it a lot. You can dig in and really get a sense and tell what that is. So sometimes there are very legitimate reasons why somebody might have a reason to be dismissed from a jury. They know one of the people who might testify. They have some experience with the plaintiff or the defendant or the lawyers, those can be just reasonable grounds that are specific to that case that juror shouldn't sit. But if the juror's just trying to get off, and you can tell that, the judge might not let them off just because.
Just because, okay. Debated and now often in the news is the issue about once a jury has done their duty, that their names be disclosed. Should they, shouldn't they be? And often the right to open records that journalists claim has become such a contentious issue. What's the status? What's the law right now? And tell me what your thoughts are about that.
So,
as others ask.
Yeah, there's different types of cases that you might really want to protect the identity of a jury. And I'm not sure what the rules are for the court to be able to do that. I think they should be able to do that to some degree. High-profile criminal trial
yes,
with
precisely.
Gangs or whatever. I would want to try to protect that jury. Now, the media will often say, well, we would like to be able to speak to the jurors about the case. And if it's a civil case, it's really hard-pressed for the court to deny the media the right to speak to the jurors. The judge can tell the jurors that they have a right not to speak to the media if they don't want to, or the press, but the court doesn't, I believe, have the right to block the media from being able to speak to jurors after a trial is over.
Does the judge have a chance or an opportunity, say someone is threatened and they report that to the judge, does the judge then have the right to say, we're going to make sure that you can't and you should not, and no media will be allowed, and no, you can't speak afterwards? Does that happen if someone receives a threat of any kind?
I just want to understand the whole question from the beginning to make sure I'm giving it to you the right way. So we're talking about after a trial is over.
Say during the trial, while there's, say they haven't been sequestered, and there is someone who gets a veiled or maybe even blatant threat, and they report that.
Yeah, so
now what happens?
No one's allowed to talk to a juror during the trial.
That's the law, right?
Yeah, the jury can't even speak to each other about the case until it's given to them for deliberation. So if someone contacts a juror and threatens a juror, the judge absolutely is going to have to know about that and take action. And there's a number of different things a judge can do if someone's being threatened.
So that's been a question that's come up. So what can happen? Does that make him automatically say, listen, we're far enough along, we want to see this case through, we'll sequester them so nobody else gets to them? Doesn't mean that they couldn't be threatened afterwards. I mean, how does...
Yeah,
so it's an issue.
Depending on the situation and the type of case and everything, that is, if you need to sequester a jury to protect the jury so they can make that decision at the end of the case free from any threats, then that's what the judge can do. There are other things the judge can do, including having the threats investigated by the police, state police perhaps. They can, if the juror has really been threatened and it's just one, perhaps remove the juror from the case. That's why you have the alternates. So there's a number of things that can be done, but it's totally grounds for a mistrial if there's a threat to a juror and nothing is done to protect the jury and the judicial system, and it's taken very seriously.
Once the jury is impaneled, if they're not sequestered, are they allowed to watch news, read the papers, follow along on what the commentary is? Are they allowed to, encouraged to, or prevented from talking to their neighbors about it? How does that go?
Yes, you're not allowed to talk to anybody about the case or the evidence that's been presented so far, or do your own independent research about anything you've heard. All of the evidence has to be the evidence that's presented at the trial through the court, and nothing can be done by a juror to find out more independently. So the judges will instruct the jurors that they can't do independent research, that they can't talk to anybody about the case, that they can't talk to each other about the case until it's given to them.
And then once the event is done and a decision's been made, what about the book deal? Are jurors allowed to, not allowed to? Certainly, I'm sure it's discouraged, but it happens. What's the law about that?
So again, I don't know that there's a specific prohibition against a juror writing about their experience on a trial. It's not common, I don't think, but most jurors' experience on a trial isn't on a high-profile trial that anyone's going to want to read a book about, although I kind of think it might be interesting for someone to write about their experience as a juror at a trial just in general, because I find it interesting from an attorney's perspective as to what people might think about their service on a trial.
And to your point about that, the idea of having an educated jury or juror, the more that people get to know about what that experience is like and what issues they confront and how they're grappling with it and how they're dealing with it, that certainly leads to a more educated potential juror. So in terms of, you say that it's a community service, it's supposed to be part of your civic duty to be, if asked, to serve. Certainly the better informed and more understanding you have about it, that certainly suggests that it would be a good thing.
It is a civic duty.
It is.
And it is, when we talk about educated juror, I never got back to that. To me, an educated juror is somebody who has a full life experience and can draw on their life experience to relate to determining what facts can be inferred from a case, what makes sense, what doesn't make sense, what's believable, what's not believable. So I look at a juror's life experience as the education that would be helpful for a trial.
And in the short amount of time, suppose someone's talking about a sexual abuse case. There are a lot of them, certainly. If you have someone who is able to weigh facts and has some empathy, a potential good juror?
Yeah, I mean, it depends what side of the case you're on.
Sure.
And what their life experience has been, but certainly the more life experience that they can draw on to work through what they're hearing for evidence, the better.
What about high-profile cases and celebrities? Does it make it better for you to have an educated juror?
Well, the bigger issue there is what knowledge do they have about the case?
Yes.
What's their experience, their feeling about the celebrity that's on trial? Those type of things that might impact their ability to be fair and impartial.
It seems like there's so many facets of that we've not even been able to scratch the surface of, but I think that this is a good way for us to at least get at. One other quick question, who decides who the foreman is?
The judge.
The judge.
Yep, and it's usually just whoever the judge randomly picks sometimes, or whoever the judge thinks might be. But the judge will give this instruction. You're still one of 8, 6, 12, whatever. Your position holds no more weight than anybody else's.
Good to know. We've covered, I think, most of the questions that have been submitted. We thank you for tuning into The Law Matters, because as we tell you, it matters to you.